quote, when the evidence is already so full that some witnesses to the same point cannot be reasonably expected to be additionally persuasive, but this power should be exercised with caution, unquote. Further, under Rule 119, Section 11, Paragraph C, quote, the prosecution and the defense may, in that order, present rebuttal and non-rebuttal and sur-rebuttal evidence unless the court, in the furtherance of justice, permits them to present additional evidence bearing upon the main issue, unquote. In People v. Tan, decided by the Supreme Court in 1999, the High Court ruled it is within the sound discretion of a trial judge to allow a party that has rested its case to introduce rebuttal evidence. Further, under the Rules of Court, Rule 135, Section 1, quote, justice shall be impartially administered without unnecessary delay, unquote. Under Section 5, entitled Inherent Powers of Courts, quote, every court shall have power, letter D, to control, in furtherance of justice, the conduct of its ministerial officers and of all other persons in any manner connected with a case before it, in every manner appertaining thereto. Parenthetically, in the President Clinton impeachment case, the U.S. House of Representatives impeached him for perjury and obstruction of justice on 19 December 1998. The Senate trial began on 7 January 1999. He was acquitted on 12 February 1999, or a little over only a month. Therefore, I humbly submit that this impeachment court, after nearly 5 months, contrast this with the 1-month trial of President Clinton. After nearly 5 months, this court possesses authority to order the conclusion of trial on or before June 7, so as to allow judgment to be promulgated before Congress ends this session. Let me now move on to point number 2. Is it relevant to the impeachment proceedings that the sale to the City of Manila of land owned by Basa Guidote Enterprises Incorporated, represented by Cristina Corona, was disallowed in audit by the Commission on Audit following this timeline? In 2001, the negotiated sale was consummated. The city government took possession of the property and constructed a public market on it. Ms. Corona received a check worth some $35 million, allegedly in trust for BGEI. She deposited the check in her own account. 2002. 1 year later, COA issued a notice of suspension of payment. It appears that the City of Manila took no action because of alleged failure to serve the notice properly. Hence, under the State Audit Code, the transaction remained an unsettled account. The notice of suspension was based on alleged failure to submit certain documents, that is, the original copy of the deed of absolute sale, the TCT in favor of the City of Manila, the recommendation of the appraisal committee, and copy of the latest tax declaration transferred from the owner to the City of Manila. And then, after these developments, in 2001 and then in 2002, in March 2012, or after 11 years, COA issued a notice of disallowance. In Carabello versus Court of Appeals, decided by the Supreme Court in 2009, the court ruled that the term unexplained matter normally results from non-disclosure or concealment of vital facts. It appears that the Corona Sang did not conceal the vital fact of the sale. In his 2003 Sang, Corona mentioned the item, quote, cash advance from BGEI, parenthesis, Wife's Family Corporation, parenthesis, of 11 million pesos, unquote. The Corona Sangs do not include the purchase price of 35 million because Cristina Corona apparently received it from the City of Manila in trust for the corporation. The 1994 Sang form did not require the declaration of trust arrangements. Subsequently, the 2006 to 2007 Sang manual required the declaration of assets held in trust, but the Civil Service Commission has deferred the application of this manual. Remember, our basic issue here is it relevant to deal with the alleged irregularities in the sale of land? In law, the term relevant means logically connected and tending to prove or disprove the matter in issue. It means having appreciable probative value, that is, rationally tending to persuade people of the probability or improbability of some alleged fact. The word relevant means that the COA notice of disallowance and the failure to include the purchase price of corporation property in the Corona SAL should be so related to each other that one fact tends to prove the other fact. Under this definition, the COA notice of disallowance is irrelevant to these impeachment proceedings. Under the Rules of Court, Rule 128, Section 4, entitled Relevancy of Evidence, quote, evidence must have such a relation to the fact in issue as to induce belief in its existence or non-existence. Evidence on collateral matters shall not be allowed, except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue, unquote. In the case of DePaul v. NLRC, decided in 1999, the Supreme Court ruled, quote, a party alleging a critical fact must support its allegation with substantial evidence, and any decision based on unsubstantial allegation cannot stand, as it will offend due process, unquote. Therefore, applying the test of relevancy and under the principle of criminal due process, I humbly submit that any evidence tending to prove any irregularity in the sale of BGEI property to the City of Manila would be irrelevant to impeachment proceedings over the alleged omissions in the SAL of the defendant. Evidence on alleged irregularities should be presented to the Solicitor General for litigation in court. I humbly make these submissions to our colleagues in the impeachment court. Thank you.
Thank you. Noted. Majority Floor Leader.
Yes, Mr. President, in our last hearing, the prosecution has asked for the continuance in their cross-examination of former Manila Mayor Lito Atienza. May we inquire from the defense if they are ready to present Mayor Atienza for the continuation of the cross-examination?
We are, Your Honor. We will call him to the stand for continuation of the cross-examination by the prosecution, Your Honor.
Then proceed.
May we request for a minute, Your Honor? We'll call him.
By the way, what is the fact sought to be proven by the presence of the former mayor of the City of Manila here?
If Your Honor, please.
Yes.
The cross-examination had already gone to the extent of narrating in details the alleged circumstances surrounding the acquisition by the City of Manila of these properties and the payment, therefore, in the amount of 34.7 million pesos, Your Honor.
Only to the extent that there was a payment of 34.7 million pesos.
Your Honor, we introduced evidence to that effect in order to show how Chief Justice Corona was able to acquire allegedly some properties which do not seem to be justified by his reported income.
So, in effect, given the statement of the lady from Iloilo, nonetheless, the position of the defense is that the transaction is relevant, the transaction between Manila and the Guidote Corporation is relevant to this case to the extent of the proceeds of the sale, which will now be treated as a part of the funds used by the Chief Justice to acquire properties. That it?
That is correct, Your Honor.
All right, proceed.
Din, pinusundo na? Pinusundo na? May we request the indulgence of the court for only 1 minute.
All right, 1 minute suspension.
Tinatawag po ang former Mayor Lito Atienza sa witness stand. Itutuloy po ng prosecution ang kanilang cross-examination. Itong testimonya ni former Mayor Atienza ay may kinalaman sa Basa Guidote Enterprises.
Kanina rin pagkasimula nitong trial, Attorney Mark, ay binasa itong isang liha mula kay Secretary Laila de Lima kasi para sa ating mga kababayan, siya po ay kinukuha ng depensa bilang isang hostile witness upang sagutin ang ilang mga bagay. Ngunit sinabi niya sa kanyang liham na maaari daw na hindi na siya pumunta sa ngayon dahil nasagot na niya sa kanyang pagkakaalam ang lahat ng kinakailangang kasagutan o kinakailangan malaman dito sa paglilitis na ito.
Nakikita natin sa ating screen, naglalakad na po papunta sa witness stand si former Mayor Lito Atienza. Maya-maya lamang po, makakapanayan pa rin po natin si Attorney Trixie Angeles para ipaliwanag yung mga unang kaganapan nitong trial sa araw na ito.
Distinguished former Mayor of Manila will now please take the witness stand and testify under the same oath. Thank you, Your Honor.
Mr. President, may I request that one of our private prosecutors be recognized to continue the cross-examination, Attorney Renato Samonte Jr.
Let it be noted that the request,
Thank you.
the request of the prosecution is noted. Proceed.
Good afternoon po ulit, Mr. President and Your Honors and Mr. Mayor. May I proceed, Your Honor?
Go ahead.
Ginoong Mayor Atienza, last time when you testified on the reg examination, you made mention and presented at least 4 documents in the forms of endorsement from your city government in connection with this negotiated sale transaction involving Basagidote Enterprise. You remember having done that last time.
Opo.
In fact, exhibits 234, 235, 236, and 237 were marked in evidence by the defense. You remember also having identified these documents.
Yes, Your Honor.
And these endorsements were signed by your responsible officers, City Legal Officer Melchor Monsod for 234, Emmanuel R. Sison, your secretary. Another document by Attorney Sison. And the last one by City Treasurer Liberty Toledo, City Accountant Kilantang, and Budget Officer Musa.
Is there any question about those?
Yes,
details?
we're about, I'm just
Why
saying.
don't you just go direct to the point that you want to bring up?
Yes, Your Honor. Now, Mr. Mayor, in all these 4 documents, you will agree with me that the entity mentioned here is only Basagidote Enterprise Incorporated. That's correct.
Opo.
There is no mention here of Intrust for or Cristina Corona Intrust for Basagidote. None.
Opo.
Last time also you mentioned of the check that you ordered to be issued in favor of the seller, Basagidote, as represented by Cristina R. Corona. That's correct.
Opo.
It was you as the city mayor who ordered for the issuance of this kind of check with that interest for praise. That's correct.
Hindi po ako personal.